Okay, again, welcome to the CalOES Sexual Assault Training Standards, Materials, and Methods, session 4. Thanks so much for joining us today. We are excited to be hosting our 4th session to talk about the standards and regulations in the new CalOES application and sexual assault counselor advocate training standards. So we'll be discussing a few units today. This is our second to last unit in our 5-part web series. So we will be meeting here today and then concluding our series on Friday, July 31st. Today, we will be discussing 3 units. So we'll be looking at Unit G, which is multidisciplinary engagement, Unit H, which is medical, and Unit I, which is law enforcement. So we'll be kicking off our 4th session by digging into all 3 of these topics. So we have a lot of ground to cover today. Leah, I will hand it to you to talk about this session's learning objectives.
Okay, so thank you very much, Sarah. I appreciate that and appreciate everyone being in attendance today. Again, just to remind everyone, we are not talking about how to deliver this content. That will be forthcoming in a fabulous curriculum that we would like to, that Sarah and I will be working on, and we are soliciting from all of you the various strategies and approaches and activities and guided discussion prompts and so on that you use to implement this content. That is forthcoming. We'll have that by the end of September. But instead, this session is really intended to emphasize whatever changes that were included as part of the training standards for your purposes of certification, and to really kind of focus in on what it is that we want to make sure we're delivering to advocate counselor trainees, right? That's like the intent, the spirit behind much of the training standards. So again, we want to make sure that we like what's the spirit behind the training and the information that needs to be imparted to our advocate trainees behind multidisciplinary engagement, medical services, and law enforcement, right? And then to make sure that you understand what you need to do to be in compliance with those units as you, if you need to do recertification or your applications for your rape crisis centers. So, and this is specifically for units G, H, and I. Next, oh yeah. Just to give you a heads up also, we have additional trainings that are on the horizon. On August 11th, we will spend some time looking specifically at best practices for service delivery for working with trans and non-gender and gender non-conforming populations. That will be presented and facilitated by Bambi Salcedo with the Trans Latino Coalition. And that is August 11th, 10 to 11:30. And then we will have a 2-part session similar to this one, but it's a 2-part session. It's actually a makeup session from a day-long in-person training that we had, but kind of got backburnered as a result of COVID-19. So we have moved it online, and it will be August 18th and August 20th on confidentiality and mandated reporting. That is a 2-parter. I definitely encourage and urge you to all be sure to sign up for those. Be looking for those announcements, those alerts. I believe the Transforming the World one actually went out today. So if you haven't had a chance, be sure to take a look in your inboxes, because I'm pretty sure that went out at 8 o'clock this morning. Okay, thank you. Go ahead, Sarah.
Yes. So we are going to be diving into Unit G, multidisciplinary engagement. The minimum time to complete this unit is 2.5 hours. That leaves us with a media allowance of 15 minutes. Again, folks are allowed to have 10% of the overall training content be some sort of media. And so this would be if you were doing that 10% evenly distributed across each unit. So again, you can kind of mix and match and use more or less in some units, just as long as it all balances out to 10%. But we put this here just to give folks an idea of about how much media you could show if you did want to use media in this section. So that would be 15 minutes. And this unit does not require a subject matter expert. So just some quick desired outcomes and key concepts for advocates. Again, this is kind of the purpose of the unit. This is what we want folks, advocates that go through the training, to be walking away with. So after learning about multidisciplinary engagement in Unit G, advocates should be able to describe basic principles of effective survivor advocacy when dealing with various systems and service providers. Obviously, of course, this includes medical and law enforcement, prosecutors, as well as some institutions that we'll be talking about today, such as military, corrections, and higher education. Lastly, it's important that advocates walk away from this unit being able to implement the skills necessary to maintain appropriate confidentiality and boundaries, so important, while upholding the survivor's rights when working in multidisciplinary settings. So we know that a lot of times working in these multidisciplinary settings can be kind of tricky. A lot of times the advocate's role is either invalidated or misunderstood. Folks will, try and pry information out of the advocate. So going through this section, advocates should really be prepared for the different ways in which that can look, and different strategies for being survivor-centered and maintaining that confidentiality and appropriate boundaries, not only with the survivor, but with the other members of their team as well. Back to you, Leah.
That was so well said. I could just listen to you all afternoon. Like, keep going, Sarah. Okay, thank you very much. So a little bit about where this multidisciplinary engagement thing comes from. We understand, or we mark this idea of working collaboratively from amongst many responders to both domestic violence and sexual violence back into the late 70s and early 80s. Some of us who've been around a long time, although I wasn't part of the whole, domestic abuse. Duluth, Minnesota, is really the one that in 1980, they're the ones that we point to as really kind of initiating this idea of bringing domestic violence advocates and district attorneys and law enforcement officers and medical professionals and the like all together to discuss issues of gender-based violence, interpersonal violence, and all of those other kinds of things. That model has been taken up and replicated all over the world. It just makes sense for people to work in a coordinated way, right, to improve the quality of life and the healing and recovery of survivors, in this particular instance, specifically of sexual and or domestic or dating violence, right? So there is a long tradition, and it is clearly understood as a best practice for those people who are responders, and even those folks who are doing prevention work around sexual assault and domestic violence. So everybody understands it. It's been around a long time, and it is an ongoing practice. As a matter of fact, if you're working in a community where people do not have some form of responders coordinating their efforts, maybe we should take a look at that. Okay, so if you can get the next slide. So what you really want to make sure that you are understanding about this is that we have more entities now addressing sexual assault in ways in which they had not previously, right? We have medical providers who are really kind of, it's not just pro forma, but they understand that there's a particular kind of specialty that goes along with working with sexual assault and working in sexual assault and sexual assault survivors. That law enforcement is paying attention to sexual assault in a particular kind of way that is different from other major assault crimes that they are dealing with. That prosecutors have particular kinds of protocols and things that they're supposed to be paying attention to. And then there's the role of the advocate. And so when you have all of these different systems or institutions coming together, what winds up happening is that our rape crisis advocates, who were very instrumental in advocating and insisting that these responders pay attention to sexual assault in a way that centers the survivor, right? The way that centers the survivor, that you have entities that really privilege or prioritize their objectives or their goals in responding to sexual assault. And sometimes it doesn't necessarily take into account the needs of the actual survivor, right? It doesn't necessarily do that. So we want to make sure that for your advocates need to really take away from the training of this particular unit is that they need to understand that there needs to be a clarity of roles, right? Everybody needs to understand which lane they're riding in, and they need to make sure that they stay in their lanes, okay? Because there is a whole lot of stuff that can go wrong if people are not paying attention to and adhering to the very clearly articulated roles that they each have, right? So your advocates and sitting around a table, just imagine sitting around a room and you have a law enforcement officer and you have someone from the DA's office and you have a medical professional and you have the advocate and so on. Each of those entities will refer to the person who has experienced harm in different ways, right? So the law enforcement officer will refer to them as the victim. The prosecutor will refer to them as the witness. Your medical professional will refer to them as a patient. A therapist might refer to them as a client, or if we're talking about co-occurring issues, somebody might refer to them as a consumer. And then we in the sexual assault field will refer to them as survivors, right? So with our understanding of how to interact with the survivor, we each have different objectives, right? Ultimately, or at least theoretically, all aimed at the same goal, which is for us about healing the survivor's road towards recovery and healing, right? Well, the prosecutors end game for them is a successful prosecution, right? So your advocates need to understand what the role of each of those responders, what those roles are, and to be clear on the boundaries between those different roles and to ensure that they don't get bowled over, right? Because their goals are, or because their end goal is different from everyone else's, right? We want to make sure that we want the individual to be healthy and healed, but we have different outcomes that we may be working toward. And sometimes that might generate a little bit of conflict. So your advocate needs to understand people have different roles and they may have different outcomes and they may have different ways about going about doing that. And your advocate, this is a counselor advocate training. We went over the counseling part. Now here's the advocate part. Here's the advocacy part, right? And it can, you know, it can be fun. I mean, it can be challenging is what I really mean by that. So let's move on. We want to spend a little bit of time going over these various kinds of systems and institutions in which your advocates may be operating on behalf of survivors, right? Either in terms of response and responders, working with responders, protocols, how they engage with survivors, or even in a prevention capacity, right? You know, if you're on if you're working on a college campus or if you're working with a military group, you can imagine that they have different systems. So the military is what we would call a closed system, which means that they will respond different. They have a particular way in which they want to handle sexual assault claims, right? They have an internal process and they have their own jurisdiction, right? There are certain barriers that survivors may confront. They may be concerned about their careers being jeopardized as a result of filing some kind of complaint against a superior or a colleague, right? So there's those kinds of things. And typically within the military, they have their own internal processes. Advocates may be called upon by survivors as an outside source, largely due in part because they're not having their healing recovery needs, or they're not being centered in that process as that whatever that military process is moves forward, right? So you can have an advocate, a survivor that says, you know what, I need some additional support. And you have different branches of the military that will work with local rape crisis centers to come on base, to be of support, run groups, and so on, and work in partnership with them, right? But understand that that is a closed system, and they can work they want to work their own internal process. Similarly, if we can go to the next slide, When we think about educational institutions, that is also considered to a large degree a closed system. They have their own internal process. When a claim is filed within an academic institution, it is not considered a criminal offense, but it is considered an offense against student conduct typically, right? So they have their whole adjudication process in which an advocate, a confidential advocate, may be engaged to come in and provide needed response services, counseling, support, work with student affairs to handle certain accommodations for students and the like, right? But they nevertheless have their own ongoing internal process for investigating and dealing with that. Again, unique barriers associated with that. You have students that are concerned about things like their academic career. If nothing happens on the campus, you have many survivors who wind up feeling like they have to leave the school because the school is not responding in a way that centers the survivor's needs. And then you have college campuses that pose an increased risk for victimization or violence because you have students, kids, young people who are young adults who are away from home for the first time. And then you can have different kinds of atmospheres that unfortunately create the conditions for violence. Invariably, again, this becomes one of the reasons why sometimes campuses, because of their own internal practices and traditions, they want to respond to claims of sexual assault on their own terms. That does not mean, though, that students cannot go ahead and have a criminal response to an assault that happens while they are in college also, right? So you can have an investigation that's happening in relationship to a campus, but then they can also work with local municipalities and law enforcement to file a claim. You obviously invariably do not want conflicting investigations happening, but your advocates need to be sure that they communicate to survivors what their rights are and what they have access to. Also, when we think about prisons, jails, and detention facilities, if we could go to the next slide. And again, we're talking about another closed system, right? And what's unique to this system is that you have people who, when detained or incarcerated, may have high probability for previous experiences of domestic or sexual violence, right? And so then they become detained, and that may impact them in a particular kind of way around trauma and triggering. And then you also have people who are in detention who experience sexual violence and abuse and exploitation while in detention, either from other detainees or from people in positions of power, guards and the like, right? So that is another closed system that wants to be able to address and deal with issues of sexual violence within their system and follow their own protocols and policies as well. So for the clarification for your advocates, if you could go to the next slide, for your advocates, right? You want your advocates to make sure that they understand that they're there on behalf of the survivor and to continue to center the needs of the survivors, right? But when you are working within these different systems and institutions, it's their house, it's their rules. It's their house, it's their rules. See, one of the unintended outcomes of the field being so effective in insisting that these other systems and institutions take on addressing issues of sexual violence is that those systems and institutions began to act as though they no longer needed the field. They no longer needed the community-based rape crisis domestic violence organization to participate in the response or healing recovery and what have you. So for us as advocates, we want to continue to remind them that we are there for the express purpose. What makes us different from all of the other systems and institutions, that we are there for the survivors, to advocate on behalf of survivors' needs, right? They have different objectives. Our objective is to stay focused on the needs of the survivors and their advocacy, to support the survivor Maintain confidentiality. We're going to talk about that several times today, and really I want to encourage everyone to sign up to attend the two-parter on confidentiality and mandatory reporting. But you want your advocate to understand that they may not give the impression that they are part of any of these systems. They can work along with these other responders or these other systems and institutions, but they cannot be seen as an agent of the state or these other institutions, right? So you're going to want to work with your advocates to make sure that they have clarity around those kinds of things. Other things that on here that I would want to just deliberate on for a little bit longer is that your advocates really need to understand the difference between a victim advocate and a support person. Victim advocates are part of California's statute, which means that it is part of what survivors are entitled to access. Law enforcement personnel and hospital personnel are, hospitals can make a call to a rape crisis center. Law enforcement shall make calls to rape crisis centers, right? But your support person is not necessarily trained. They do not have confidentiality and privileged communication, right? But survivors are entitled to have a support person and or a victim advocate. So you want to make sure that they understand the distinction between the two. Again, victim advocates are a part of the statute, and as a result, there are certain privileges that go along with that, including confidentiality, privileged communication with survivors. Support persons do not. Be clear about our boundaries and working with all of these other people who are part of the response teams, right? Want to make sure we're very clear about that. And then what it means to have vertical versus non-vertical service delivery. So you can have an organization that works from soup to nuts. One person works with that survivor from start to finish. And then you have different organizations that will have people specialize in particular kinds of needs. And so you can have more of a team approach to working with survivors. You want to make sure who has privileged communication and confidentiality in either case. You want to make sure, be clear that your advocates are aware of that and what those distinctions are. Okay, if we could go to the next slide. I know I'm going very, very quickly, folks, and I want to check out all of your comments in the chat box. Give me a second and I'll be sure to do that. Also, here's the community partners. Again, make sure your advocates know that they might be working or coming into contact with myriad folks who are responding to, and your advocates need to always understand that they're on the part of the survivors, which means confidentiality. For this purposes, or I want to highlight this idea around confidentiality and privilege, you can find that you get very comfortable and familiar in working with these folks when you see them out, if it's on a campus or at a hospital. You speak to the same kind of sane or safe nurses. Sometimes you encounter the same kind of law enforcement officers. You know them, maybe you know them by, you know them by their first names. They know you. You're their go-to advocate when they have to deal with issues of sexual assault, right? So our advocates will formulate relationships with these other responders that we work with, and we have our kind of collegial relationships. Your advocates cannot share information about the survivors with any of these other responders. Sometimes the other responders might put pressure on them to reveal that. They'll say, oh, well, you don't care if this person has a successful trial if you don't give us this information. What's the big deal? I'm going to get them to tell me anyway. And you say, well, if you can get this information directly from the survivor, then so be it. But you as the advocate are not allowed to get so friendly, buddy with with the other folks that you work with in communities, right? That you are breaching confidentiality and breaching trust, okay? So confidentiality, it is a large umbrella term, right? It's a broad designation that determines a set of practices that protect personal identification of survivors. But privilege, we want to make sure that we understand the distinction. Privilege under that umbrella, excuse me, I'm going to sneeze again. Under that umbrella is a legal designation, right, that bars those with protected communication from disclosure, right? So it is a legal designation that prohibits the disclosure of confidential information, right? So with that, Sarah, why don't you go ahead and tell us what we're going to do next?
Sure. So in the chat, we were looking just for folks to contribute in the chat and put in, what is your definition of how privileged communication is different from confidentiality? Is this already something that you're talking about in your trainings? If so, if anyone can share kind of like a easy, like bite-sized piece of information in the chat, just fundamentally, how is privilege different? How is privileged communication different from confidentiality? So that's question number one. Question number two, and this is just a yes or no, can you share information about a survivor with your sexual assault response team, with the other members in your disciplinary team, other members in your multidisciplinary team? So I will drop these two questions in the chat. And then if folks are able to answer, that would be great.
Yeah, I mean, I just, as people are dropping their comments in there, I noticed that Michael was referencing legal counsel, the colleges and universities, especially with new regulations from Title IX. It feels very legalistic. The whole process of dealing with sexual assault on college campuses is becoming very legalistic, and kind of really kind of tipping out of the tipping the balance, you know, where the complainants and the respondents are hiring full-on like really expensive attorneys, and you know the complainant has access to an advocate for themselves, and it may not necessarily be an attorney, right? So you have an advocate, community-based advocate, having to be the support person against a respondent who has an attorney. So if we can find, hope we're all looking for great legal resources for students on college campuses who are dealing with sexual assault. The BSA, Michael, I don't know what the BSA is, so you might have to lay that out for me. And Catholic and other clergy try to resolve. That's another system. That's an internal system. They're supposed to have protocols, but you know they're another one that wants to deal with it internally, right? But they are not absolved from dealing with the kind of criminal aspect of what's going on within that institution, and consequently, we see a lot of the things that they're dealing with. Non-vertical. We do non-vertical so that the client doesn't rely on one person for everything. Katie is sharing with us. Either model works, and I think it's important that your organization has an understanding or has a process in place for dealing with either vertical or non-vertical prosecution. I mean, not vertical and non-prosecution. I'm just looking at what's happening to the screen. It's all the tech. We got goblins in the system. So it's good that if you have the resources and you can have different folks providing different kinds of advocacy within your organization, that's great, right? And then that way you don't have, as Katie states, you don't have all of the burden of advocacy falling or relying upon one person. So that's really good. So in looking at the difference, I'm sorry, Sarah, go ahead. Looking at what folks have dropped in the chat.
Oh, no, you go ahead. I need to, I got kicked off for a minute, so I need to reset my things.
Great. So in thinking about privileged communication, how it's different from confidentiality, and the definition for vertical and non-vertical, just to reiterate from Mark, the vertical versus non-vertical is if you have an advocate that meets them on the scene, then works with them at the hospital, participates in their, if they have to go downtown for an interview with the district attorney, and then, you know, they follow up and so on and so on and so on. Some centers, some organizations have different people or people who specialize, so it's non-vertical. right? So you can have one person that does the in-person counseling per se, but then they may be referred to a court accompaniment advocate within the same organization to handle that aspect of responding, of a survivor's response. And then there might be someone else that you refer within your own organization that handles like victims compensation kind of things, right? So you spread it around, right? Okay, good. And can you share information with your information about a survivor with your SART? Jen, can you, first one, you're still having trouble explaining a bite-sized way, even though you had trouble, you just had, you're still trying to figure it out?
Yeah, just like the wording for it, like whereas most things I have like a 1 or 2 liner I can give, like confidentiality is easy for me to explain, like anything said here stays here as long as, you know, and your information is protected as long as there's not a third party in the room. But privilege is something that I'm just now starting to tease out from confidentiality, and something that we've been teasing out in our agency. So I don't fully understand it, other than, you know, that gives us the ability to like not have to share anything in court without that survivor's like explicit permission. And we would have, you know, conversations around the helpfulness or harmfulness of sharing that with the survivor before we like would respond to a subpoena or something.
Good. So, and as Katie points out, privileged communication is it resides with the survivor. The survivor can waive, right? They can waive that. You know, I used to be, when my center that I worked at in LA, every once in a while we would get a request that was signed off on by a survivor as part of a legal proceeding. But we as the advocates are not able to breach or disclose that protected communication, right? We as the advocates have to maintain confidentiality, meaning it's gonna stay here between us. You can work within a disciplinary team and talk about an assault or some particularities, but you cannot give up any identifying information, right? Anything that would specifically link to a survivor. But if there is a privileged relationship, you are prohibited from sharing or disclosing anything that has been shared with you by the survivor. And so our rape crisis centers are able to, with this training, and that's why it's important that we stay certified in compliance with our trainings, because that is what allows the rape crisis centers to be able to claim that anything shared with them from a survivor is privileged. Does that make sense? Okay. All right, excellent. But we're going to spend a whole bunch of time, like 4 hours, talking about privilege and mandated reporting and confidentiality on the 11th or the
18th and 20th, I think.
18th and 20th. Thank you. What would I do without Sarah? Okay, so if there aren't any other questions, and I don't know where we are in terms of our agenda. We can take a break.
8 minutes early for the 10-minute break. So we do have time for questions if folks have any questions, or we can also head to break early and we'll just be back a little bit early, which will leave us more time for medical and law enforcement where there might be more questions too.
Any questions? Anybody want to go ahead and unmute and ask a question? Otherwise, we can take our break a little early. Sometimes law enforcement may openly present info on the survivor, sometimes quite a bit. Yeah, we know. It can be kind of messy sometimes. Is it okay to absorb that information, but as an advocate, we cannot reciprocate. Absolutely not. As a matter of fact, Mark, did you want to elaborate or share a little bit more about that, with your experience with that? I think it's a trap. I think they're trying to trap you and make you all comfortable and casual, and then you'll oopsie, kind of.
Well, okay, in San Luis County, well, in my county, we the officers, RISE has spent a lot of time with law enforcement, in various committees and advisory boards. And so I think we have a good relationship with law enforcement. So a lot of times they'll just start talking about the survivor with details that I kind of don't need to know about at all. But stuff they've just developed in the last hour working with a survivor and trying to get evidence. And so I'll take that in, but I realize I can't say anything to respond. It's kind of like, I can't confirm. I can't say, well, yeah, you're right, because she said that too. I can't say that. And so you got to be careful not to just take that in. But this is a professional setting where you can't. In any other job, you might reciprocate with some more information, but you can't as an advocate. So you just got to watch that. That's all.
And it could be something as simple as, yeah, they said the same thing to me too.
Right. Exactly. Yes.
No. And so I think that I think an important word in what you just shared, which is like the advocates need to remember that there's a level of professionalism, right? And you want to be taken seriously by these other professionals, right? You have the doctors and nurses,
yes.
and you have the lawyers, and then they look at you as an advocate, like, who are you, right?
Right.
And you, as an advocate, actually have a lot of power. Mm-hmm. And you have access to a lot of information that they want, right? So we want to make sure that these relationships are not hostile or confrontational, but we're just clear that you are operating there as a professional, among professionals. And you know what? I just cannot share any of that information. Thank you for, but I'm happy to, if there's something else I can do, right? So your advocates really need to kind of keep that at the foreground, because they'll sweep you up. Right. And become very casual, right? So you want to make sure that we're paying attention to that.
Right.
Any other questions or thoughts?
This is off topic, and this is just really a question for me. I don't know about anybody else. We did a DVSA certification about in 2017, and we're thinking about pulling it apart to just pull the essay portion. Do we have to recertify if we just pull the already certified training that's DVSA together? So like say I'm just pulling the essay out of that. Do we have to recertify?
You know what? I think you do.
Okay.
But if you would do me a favor, Katie, send an email either to myself or Sarah. Mm-hmm. We can verify that for you. But I believe because the certification process, you have to do it anytime you significantly change what you have already submitted for certification. So if you're going to pull those apart, especially if you had, say you had somebody come in and talk about legal, and they're talking about legal for both sexual assault and legal for domestic violence. Well, you have to do 2.5 hours. I think we'll find out in a minute how many hours you have to do for legal, but 2.5 hours for legal and 2.5 hours for DV, or are they doing 3 hours for both? Mm-hmm. Right? So it's my understanding, I believe you do, but I can confirm that. I can get a confirmation on that. You will have to recertify.
Perfect, thank you.
Veronica says it's their understanding that you do have to recertify. Our email addresses are in the chat box. So yeah, if you'll just go ahead and email us, Veronica, we'll verify that for you. Or Louise says in terms of recertifying, hey, Louise, can that recertification be sent in with a fax machine? Just kidding. From our experience, any change to the program requires a new approval.
Leah.
What's that?
I will say that I have strongly encouraged our volunteer coordinator not to change the existing program because it is time consuming to change it. And one of the things that people need to be aware of is if you want to pull it apart, that's cool, but then you're going to have to do 40 hours each for SA and DV if you're still doing DV work. Mm-hmm. And that's before you add any specialty work that you'd like to do, which from my own personal experience, I also recommend that people don't, in this case, us being super cool, because we had a manager a few years back that wanted to show how great we were. What that meant was that then locked us into providing all that super cool extra stuff forever until we recertified the program.
Wow.
So one of the, we are required to do 8 hours of continuing ed training. So my suggestion to my team, and I'll happily share it with everybody else, is do a certification that meets what you have to do through CalOES for SA and meets their approval. And all the other super cool stuff you want to do, you can do it as continuing education anytime you like, and you can change it whenever you want when it's continuing ed.
Do you have an example of what you would call super cool? Are we talking about like?
Well, you know, we had, so back when we started doing human trafficking work with the HV grant back in 2016, when we started that, we started to pull in all sorts of new videos. And even for some of the things that we did, like around, like, you know, around training, around, say, working with children and ACEs, just things change in our world, you know. And if you wanted to change a media or change a segment because our update, you know, 4 years later on any subject, it's like, you know, that's a little bit dated and we really need to kind of be a little more current with what we're doing and how we're approaching it. Well, guess what? Now you have to change your certification. Now you have to get reapproved.
Yeah.
So what we've kind of thought is like, really address what's in the service standards and what is required to be in there, and make sure you address that, and then leave the neat things, you know. We can't do that much in the way of video training anyways, because of the minimal requirement. If you want to show another movie as part of continuing education. And then if a different movie comes out 2 years later that you like better or that addresses the situation better, you can change it, and it's no harm, no foul.
Yeah. So you want to meet the minimum standards, right? And and then if there are things that you're doing in addition to that, like if you're talking about, you want to add to your crisis intervention sessions, you want to now start talking about, you want to add another, because you live in a particular part of the state where you have a large number of persons with hearing, or
Right.
persons who are hard of hearing. And so you're going to do 10 hours of working with the deaf and hard of hearing population. I don't know that you want to include that as part of your certification, right? You can always do it. You can always add it, right? But you want to meet the requirement standards and don't necessarily build that enhancement or that specificity into the certification process.
Right. To me, the build is like, the way I'm looking at it now, and I'm our development person and our grant writer. So for years, I had no involvement with essay training until the people who coordinated it were all gone. And the person who had taken over comes to me and says, I don't know what to do. So that was a big learning experience. So really, there's no bonus points for doing better. So to me, it's like, let's focus on what you need to have to meet the requirements and have a boot camp. I mean, to use, you know, people have talked about like military reference or stuff like that. If you go to the military, you have boot camp, and all that you learn in boot camp is how to be a good soldier or a good sailor or a good, or a good air person. You know, after that, you attend extra training to be really good at the area that you're working in. And I think that it's helpful for people, especially if you're doing this for the first time, to look at it from that perspective. What do we need to do to meet our requirements and kind of have a baseline to work from as we train our advocates? Because everybody knows they're not ready to go on their own after they walk out of CIT. There's still going to be on-the-job training. There's still going to be one-on-one, you know, with your supervisor. There's still going to be shadowing, you know, in the real world. Right.
Right. Very good insights. Okay. Are we ready for break?
Yeah, I think so. It is just a couple minutes past 1:50. I put in the chat for folks who don't have questions, please feel free to go on break so we can stay on our tight schedule today. And we'll be returning at 2 to start discussing medical. So we'll see you back here at 2.
Thank you.
Okay, welcome back, folks. It is just about 2 o'clock. I think we can start getting back to it and continue with the rest of our series. Leah, are you back yet?
Yes.
Hi.
Hi.
Welcome back.
Thank you. Thank you. Thank you. Okay.
Ready to get started?
Yes, ma'am. Let's do it.
Okay. So welcome to Unit H, which is medical. There's a lot of content in this unit, although the minimum time to complete is only 2 hours, which is not that long. The media allowable for this unit is 12 minutes. Again, that would be 10% of 2 hours if you're doing it that way. And this this unit does require a subject matter expert, and there actually is a media recommendation for this as well. I'm sure that many of you have it. We actually discussed it in the first session as well, but just a reminder that the media recommendation for this unit is Compassionate Care, an overview of the sexual assault clinical forensic medical examination for healthcare providers. That is a very long title. It's a DVD, and you can get that online through the California Association of District Attorneys. And for those of you who are not familiar with that video, it really outlines and details the medical forensic exam process in California and has some really good information, but I'm sure that most of you have that already. A reminder about compassionate care as well is that this DVD does not count towards your 10% of media. So this DVD could be shown in addition to 12 minutes of other media of your choosing if you decide to do that. And a quick note on the subject matter experts that are needed for this unit. So the intention here is that this entire unit, so items 1 through 8 in this unit must be covered by a subject matter expert, such as a sexual assault nurse examiner, sexual assault forensic examiner. And as your role as the facilitator for this unit, you're responsible for communicating to the presenter, to your subject matter expert, all of the areas that must be covered. So even if we know that just because somebody is a sane or a safe, they don't necessarily have a ton of experience with training or facilitation or education. So you can, do your best to help them understand all of the areas that need to be covered. And if for some reason something still gets left out, that would be then, the job of the facilitator to ensure that that material was getting covered one way or another if there was things that you had to make up. And of course, the facilitator, will be available for asking questions and stuff like that too. By facilitator, I mean the Rape Crisis Center employee who's facilitating the training overall. So yeah, just a quick note there. We wanted to make sure that folks understood that the intention is that 1 through 8, so all of the units in this section are facilitated to some capacity by your subject matter expert, and the RCC facilitator will kind of fill in bits and pieces as needed. So our desired outcomes here for advocates, what we want to make sure that our subject matter expert is communicating so that folks can walk away having completed the unit, being able to describe sexual assault medical services, the basic procedures involved in that, and the personnel, so the folks who are involved in forensic exams in the state of California. Additionally, we want our advocates to be able to employ strategies to empower survivors to make their own choices and minimize trauma associated with forensic medical procedures. So sort of like Leah was saying earlier, this is really where the advocacy hat comes in and works in tandem with the counselor hat as well, of course, in minimizing that trauma. But that can look a lot of different ways, and there's a lot of nuance to that. And advocates need to be really well versed in ensuring that the survivor knows that they can kind of consent to as much or as little to the exam as they want to, that this isn't an all or nothing situation. So again, making sure that advocates know how to effectively communicate that information. Lastly, we want advocates to have the skills to address survivors' concerns of bias and institutional barriers within medical systems, as experienced by underserved or unserved populations. So Leah will talk about this a little bit when we talk about considerations for special populations, but we know that virtually every population with marginalized identities has experienced some historical trauma at the hands of the healthcare system, and a lot of these things still live very, very real for folks, and it's the advocate's role to have enough of an understanding about these historical traumas to be able to really support the survivor through that and support their decision in whether or not they want to engage with the healthcare system. Okay, so I'll turn it back over to you.
Thank you so much for that, Sarah. I concur and want to emphasize much of what Sarah has said. There have been countless trainings that I participated in a very long time ago, but nevertheless, where after training and the subject matter expert left, we had to do a lot of cleaning up. You just did. It will be incumbent upon you as the person responsible for conducting your training for your center, for your organization or your program, to make sure that your subject matter expert is clear on these areas 1 through 8 for this particular unit, and that they are talk it out with them, even though they are expert in the medical examination process. They may not know necessarily how to impart that information to advocates, right? I have unfortunately heard medical professionals and legal professionals who are subject matter experts make all kinds of generalized statements about certain ethnic groups and races, make certain kinds of disparaging comments about, I don't think that was their intention, but the way that they would reference homeless or runaway teens as a population when I work. So you may have to do some cleanup afterwards. You just want to be prepared for that. Again, for the advocates, it's very important, vitally important, that they take away from this that survivors have rights. Okay, I want to emphasize that. Survivors have rights, and it will be incumbent upon your advocates to understand what those rights are, and communicate them to the to the survivor, right? You don't have to participate in this. You have a right to access that. This is what's included. You don't have to participate in that, right? And sometimes your advocate may have to educate the professional, right? And we'll talk a little more about that when we get to the legal law enforcement section. So as part of that, there are many different pathways by which an advocate may be brought into a survivor situation, right? So you have hospitals that may call the Rape Crisis Center, right? They have to inform the survivor that you are entitled to this. This is part of this is a right. You have a right to have a sexual assault counselor advocate work with you, right? So then that will then have the hospital giving the Rape Crisis Center a call. Law enforcement shall contact a Rape Crisis Center. Okay, so the rape crisis, the advocate may show up on the scene as a result of being contacted by a law enforcement organization, right? There are so you want to understand that there are a lot of pathways to this kind of medical examination process, and that the advocate or the Rape Crisis Center may be contacted by people other than the actual survivor to have them come provide support during the medical process, right? They have a right to a sexual assault counselor and also a support person, and that hospitals are required, with certain injuries, hospitals are required to inform and notify law enforcement. So all of that kind of information you want to make sure your advocates are aware of, and so that they can be clear with survivors about what the processes are and manage their expectations, help them manage what's to come, right? You want to demystify it and make it less scary in some cases. As Sarah mentioned, we have lots of folks from different kinds of communities who are distrustful of the medical system, or don't have a practice of going to the doctors, right? They get some kind of ailment, and they might go out and get some herbs and make a tea, and so you have a lot of people who that is not part of their practice, because they have kinds of healing practices that they already do, or they can't afford it. It's not something that they ever had access to, right? So your advocate will need to understand that different people will have different relationships historically with working with medical professionals. Okay, can we go to the next slide? Again, as we talked about in units A and B, we want to make sure that we're paying attention to various cultural considerations. Certain people, like I said, don't have a tradition of working with going to medical professionals when there is an ailment. You also have folks that for whom going to a medical facility of some sort may be triggering. They are distrustful. Well, I won't digress into, medical science and all that kind of stuff, but or they don't have a tradition with going to see doctors. This can be odd to your advocates in some instances. Why wouldn't you want to go to the doctor if it's been normed out for your advocates? So for some of your advocates, it's just normal to go to a doctor, right? So they'll want to make sure that they are centering the perspective and the experience of the survivor in their either distrust or hesitancy or fears around being in this kind of cold clinical medical space, right? So that's important that they are factoring that in as they're working with diverse survivors. I'd like to linger on this can be particularly important when you're dealing with either Native American survivors or immigrant survivors, right? These kinds of things can turn their worlds upside down, right? And cause a lot of confusion and exacerbate any existing traumas that they may have. So I want to call your attention to the one in the middle right there, prohibit the use of advocates as language interpreters. Make sure your advocates understand that they are not there to function as interpreters. This is one of the ways, again, where, as Mark mentioned, you can just kind of casually reinforce something or support something that someone else has said. And if you are translating, your survivors speak Spanish and they're monolingual Spanish speaking, and you're bilingual Spanish English, and the medical professionals are English only speaking. So now you're in this position of having to translate back and forth between the survivor and the medical professionals. No, make sure your advocates are not put in that position. They could very easily breach confidentiality and be perceived as operating as an agent of the state, because the nurses, the medical professionals are treating injury, but they are also collecting evidence, right? They are also collecting evidence. And so it's very important that your advocates understand that they cannot be seen or sucked into any kind of circumstance or situation where they may be perceived as operating on behalf of the state. It will eventually erode trust for your survivor. It can impact the reputation of your organization down the line, right? So you want to make sure that they are understanding that they are not there to translate on behalf of the medical or the legal professionals. Okay, next slide, please. Okay, there's a lot going on this particular slide. Okay, so thinking about evidence collection and that whole experience, your advocates need to be sure that they understand the forensic medical exam process, that they understand what will happen. Are they going to collect their clothing? Are they going to look for DNA under fingernails? Are they going to have them undress, on top of a particular kind of drop cloth? Whatever that process is, you want to make sure your advocates understand step by step what's going to happen so that they can then manage the expectations and or fears or trepidation of the survivor, and that they understand that this is part of the process and why it has to be done, right? Including a very invasive exam of body orifices, the mouth, vaginas, anus, right? These are all potentially re-traumatizing, and your advocate will need to understand the process so they can say, this is what needs to be done to ensure that you have not suffered any kinds of injuries that are not readily, you can't see them visible to the eye right away. And you also want to make sure that they are communicating that they're also collecting evidence. This is why they have to go through these processes. It can be very disturbing, for the survivors. You also want them to know that because they're going through this medical process, it does not mean that they are required to participate in the criminal justice process, right? And then we can pull that apart, because there was a lot of confusion in the state of California several years back about, well, we're not going to do a forensic exam if they're not going to cooperate with law enforcement, because law enforcement has to authorize the exam, because law enforcement is who pays for the exam. Well, law enforcement pays for those exams, but that's of public monies. They're public monies. But if it's clear that the survivor thinks that they are not going to want to go any further with the criminal justice process, there is an abbreviated exam that forensic folks may engage in, where they're very very narrow their scope in terms of the collection of evidence, right? So you want your advocates to be able to explain those kinds of things for survivors. Also, that there are ways in which people who are collecting forensic evidence, what they can do if the assault occurred, if they're being examined within 5 days of the assault, or being examined after that period of time, so that you may be working with a survivor who is trying to figure out, and may want to take several days before they agree to go have a medical exam, so that there are different kinds of ways in which the forensic folks will be looking at that, depending on how far away we are from the actual the assault. So you really want them to take away from this, right? That you are allaying their fears. You're making sure that they understand that there can be abbreviated exams that are done. Again, they are not required to cooperate with law enforcement, right? But the evidence is still nevertheless collected, right? And the exam for injuries is nevertheless still performed, right? That one does not preclude the other. One is not contingent upon the other, okay? Next slide. 4 different ways for things that they are consenting for, so that they're going to be handed all these forms. And again, your advocates need to know what's going to happen in the process and what's required according to state law. That they are consenting to the general exam. They are consenting to having photos taken, right? So you want to be clear about that. And they can, again, not agree to participate in any of these. They can agree or consent to having their information released to law enforcement, and that they're also consenting to agree to have their information be counted as data in case people want to do research, those kinds of things, right? So they're going to get a lot of forms. Your advocates are going to probably need to be able to distinguish between the forms for the advocates and for the survivors, and let them know that this is pro forma, this is what you're consenting to, this is what you're consenting to, and so on. Excuse me. Oh, excuse me. Also, your advocates need to understand that minors 12 and up are able to consent to these exams on their own. They do not need to have adult parental consent or participation in that. That minors in the state of California, 12 years and older, are able to do that. It's also important that we keep in mind that young folks should not be forced or required to go through an examination process. This can be terrifying and add trauma on top of trauma, right? So, but that minors are able to consent on their own. For folks who are incapacitated in some way, they have to be officially declared incapacitated. And if an exam is to be performed on someone who is incapacitated, that some authorizing individual, someone who has the authority to do that, is able to give consent for that incapacitated person. So y'all remember that case a couple years ago about the woman in Arizona who gave birth to a child, even though she had been in a coma for 15 years, right? Had to perform an exam on this woman to be able to, well, I guess they took DNA from the baby and then they tested all of the nurses at the facility. But that would be an instance where someone would need to, maybe perhaps if they want to pursue it, need consent for an examination for someone who is incapacitated. Again, so you want to make sure that your advocates understand the conditions or circumstances under which consent is discussed and what what the survivors are consenting to, and who has the ability to consent on their own, and where there needs to be some kind of a authorizing another individual who authorizes that kind of exam. Okay, next slide. Payment for expense. So this is the tricky one again. And like I said, a couple of years ago in the state of California, you had law enforcement that was refusing to pay for processing of rape exams. You had hospitals that believed that they had to get permission from law enforcement first in order to conduct an exam. You had survivors that were being told that an exam would not be performed if they did not agree to cooperate with law enforcement. Bottom line, law enforcement agencies, the payment for those exams comes out of law enforcement's budgets, right? It comes out of their budgets. The survivors' unwillingness to go through the legal criminal justice system is not contingent upon whether an exam takes place or not, right? It has been clarified. It is not contingent upon, one is not contingent upon the other. I see someone here has posted in a comment that you are still dealing with those problems. Yeah, no. They are, your survivors need to know, your advocates can help inform this. And this is where I said your advocates may sometimes have to educate the law enforcement officers and the medical professionals, depending on, you know, if you're in a small town or a space where you don't have a lot of that kind of activity. And so they may not know, or anyway. So your advocates will need to know, and your advocates may have to, like I said, educate those professionals, because one is not contingent upon the other. Also, yeah, so maybe we can think about doing we should find out to what degree that this is how significant a problem this is statewide, because maybe there's additional trainings that CalCASA can offer that make that very clear, and we can invite some of your local law enforcement persons to participate in those conversations. We've done it before. It's been a long time, but maybe we can help facilitate that, right? And then you have the various penal codes in your training standards. So if you need to show it to somebody, I mean, we enumerate them. We call them out in the book. You can do it that way. Also, Sarah, in her experience, they had little info cards that were given to the advocates. So when the advocates went out, if they needed to say, you know, actually, this is not contingent upon that, this is the penal code, they had that information with them. So, you know, as part of your info packet that you give to your advocates, you may want to consider creating something similar to that. Michelle, so Louise, similar problem, reported rapes dropped by 2/3 in the past year, bringing law enforcement training. Okay, okay. And then what's the process for survivors that have their rights denied? Oy vey's mir. That's a good question. We should, then what, you know, you'll do that city to city or county to county, but in Los Angeles, what we have done in the past, and, you know, LA is kind of a beast, what we've done in the past is we have to then work with the higher ups at the hospital. We have to work with higher ups within law enforcement, whether it's LAPD, LA Sheriff, other municipal law enforcement, Culver City, Compton, or that sheriffs. But in some of these other jurisdictions, you have to work with them and say, this is the deal. You can't do this, right? That's why the multidisciplinary engagement is so important, because you're also formulating relationships with these entities. So when you inform them and you're educating them, it's understood that this is part of an ongoing relationship, right? It's an ongoing relationship. It's a huge problem statewide. Ooh, my goodness, constant battle. Okay. This is a good idea. So I'll have to, my email and Sarah's email were dropped into the chat. And it's really important that you all tell us what kinds of trainings that are important to all of you. And so we'll take into consideration, we have folks that can actually deliver those trainings for us. Oh, it's so challenging under COVID. I'll bet. Okay. So for the forensic exams and evidence collection, right, that's paid for by the local law enforcement agency, which is public money that comes from the state or comes from VAWA, right? One of those two places is where that money, a lot of it's coming from VAWA. But for additional medical treatment, your survivors will be responsible for that, either in terms of Medi-Cal, Medicaid, private insurance, or they can also apply for victims' compensation. Victims' compensation for a long time had a contingency that you had to cooperate with law enforcement. I'm not certain if that still applies. I believe it does. But if you have a survivor that is going through the law, going through the criminal justice process, then they should definitely take advantage of victims' compensation as a resource for them. Okay. Next slide. Looking at physical injury. Did I skip a slide? Did I skip a slide? Can we go back one? Oh, okay. Yeah, okay.
All right. My God, it's we're on survivors' health concerns.
Okay, got it. Survivors' health concerns. A lot of times you want your advocates, as they're working with survivors, if you can get them to encourage a survivor to get some kind of medical treatment or get checked out in some way. Again, there might be invisible injuries that they may not be aware of. Certainly in terms of sexually transmitted infectious diseases, you want them to take care of themselves. This is part of the healing and recovery process, right? Is knowing that, but also understanding that the physical injuries complicate or exacerbate kind of emotional or psychic trauma associated with the assault also, right? So you want them to think holistically. You want your advocates to be encouraging their survivors to think holistically about their well-being, mind, body, and spirit, right? You'll have a lot of adults who are molested as children, what we used to call AMACs. They may not be in have acute stage of trauma, but certainly if there were any kind of gynecological, for females, we were talking about gynecological injuries or STDs, that can have long-term lasting impacts as well. So your advocates need to build into their interaction with survivors a conversation about health concerns that may linger beyond the actual acute assault. Okay, can we do the next one, please? Okay, and then we go notification. And again, we started this conversation talking about how there are many pathways to which your advocates may come into contact with the survivors around medical response. Again, hospitals may contact the Rape Crisis Center. Law enforcement shall contact the Rape Crisis Center. Hospitals shall contact law enforcement when there are injuries, right? So you want your advocates to understand who is supposed to be in communication with what. And oh my gosh, this can be such a hot mess. But if the professionals don't know, we want to make sure our advocates know, right? So please make sure that you know what the local protocols and procedures are in your area for who notifies whom of what, right? And again, your advocate might be the one that has the clearest amount of information. And then imparts that information, again, knowledge is power, to your survivors, right? So that, no, this person is supposed to notify that. No, you're entitled to this as part of your rights, and the like. And they should also know that if they arrive at a hospital, survivors arrive at a hospital, and an advocate has not arrived on the scene yet, and they want to start the exam, they can wait until the hospital has notified an advocate. Right, so that is part of what advocates may have to educate medical professionals, safe or sane nurses about. Again, okay, so in the next slide. Now, for just a moment, we should have a conversation about boundaries. You want to make sure that your counselor advocates know, and again, we start off talking about highway, 5-lane highway, everybody's in a lane, everybody stays in their lane. It's going to be very clear. That it's important that the advocates understand that they need to maintain very clear boundaries with their advocates and very clear boundaries with the other professionals who are responding to a sexual assault, right? And we're clear about what everyone's roles are. So your safe, sane nurse should not be acting as a victim advocate. They should not be engaging in victim advocate responsibilities. They do not have privilege or confidentiality. And on the other side of that, the advocate should not be participating in any of the evidence collection process. No, hold this here, fold this there. Can you carry this from here to over there? No, right? This is, again, your advocates being clear about, I'm here for the survivor. That is your job to handle that over there. We cannot in any way, shape, or form break chain of evidence or give any kind of perception that any of the evidence or any of the process has been tainted in any kind of way, right? So again, you want to make sure that your advocates are clear about maintaining very, very, very important boundaries going through this process, right? Survivor transportation to and from forensic medical exams. Sometimes law enforcement will transport a survivor to a medical exam. Depends on what the policies are with your organization, whether your advocates transport survivors to and from medical exams. It creates a certain kind of liability in doing so, but unless you have a program that's designated and you have the kind of coverage that allows for that, otherwise people transporting survivors in their private vehicles, if you allow that, you want to make sure you have very clear policies that deal with that, and that you also want to make sure that your advocates understand the professional duties of these other disciplines and when they are infringing or impinging on each other. Okay. Any questions? I believe that is the last slide for that. For medical, yay, okay. Let me look and see if there were, in the chat, if there were any questions. How are we doing for time, Sarah?
We're doing so good. So I'm very proud of us, mostly you, right on target.
Okay, were there any questions, or we can take some questions if we have a little bit of time about the medical, or anybody have any horror stories that they want to share about the medical that we all learned
I should rephrase, we're actually 3 minutes over our time, so I wouldn't say that we had extra time.
Oh, okay.
But we're still very close.
Close enough. Okay.
I think folks can drop stuff in the chat, and well, the chat looks clear, but
okay. Well, then we will continue forging on. Okay, Sarah.
Okay. Last unit, we have Unit I, which is working with law enforcement. Another big part of the multidisciplinary team.
Isn't this everybody's favorite? Isn't this everybody's favorite, law enforcement?
I was about to say last but not least, and then I changed my course of wording. Time to complete, minimum 2 hours. Media allowable for this is 12 minutes, being 10%, and a subject matter expert is required for this section 2. So just another quick note on that, same as what we said in medical. Although this unit is going to be presented by someone who has subject matter expertise in law enforcement, usually this is a member of local law enforcement, but different agencies do it different ways. Items 1 through 7, so that's all the items in the unit, must still be covered. So the facilitator is responsible for communicating to the presenter all of the subject areas that must be covered. So be aware of that too. And again, the facilitator will also, be responsible for covering any items that are maybe missed or kind of skimmed over or not explained appropriately by the subject matter expert, as well as any questions. What we want advocates to be walking away from this section, the completion of Unit I, with is being able to educate sexual assault survivors on their rights, what their options are, and kind of help manage expectations too for engaging, or if they choose not to engage with law enforcement and the criminal legal system. We also want advocates to be able to demonstrate a basic knowledge of sexual assault laws and law enforcement response to sexual assault, including the role of the advocate. So going back to what Leah was saying earlier about the lanes, so helping the advocate to understand what those lanes are. And lastly, advocates should demonstrate an understanding of how state violence and systemic oppression may affect a survivor's willingness to engage with law enforcement. So again, super important point to hone in on. And this is going to be something that's going to be a challenge, right? As you're having presumably a member of local law enforcement presenting this unit, asking them to sort of really drive home the point of how state violence and systemic oppression might affect a survivor's willingness to engage with law enforcement is not necessarily expertise that your subject matter expert is going to have. So this, for example, would be one of those pieces that we'd want to lift up and make sure that the facilitator is really really making sure to emphasize those points with the advocates and helping them to understand why a survivor may choose not to engage with law enforcement. Okay, back to you.
Okay. All righty, very good. Yes, lots of communities are uncomfortable with engaging with law enforcement, right? So you want to make sure that your advocates understand why calling the cops is just not an option for a lot of different communities, right? Okay, so here we are working with law enforcement officers, also known as cops. And right off the bat, you want to make sure that your advocates understand, again, survivors' rights, what the survivors are entitled to. Law enforcement needs to apprise the victim of their legal right to have a victim advocate and a support person at any interview by law enforcement officers. Law enforcement officers may ask the advocate, can you stay outside? Or can you do this? Or can you be out there? Can you be? They have to tell the survivor that they have a right to have their victim advocate and or support person present during law enforcement interviews, okay? And that law enforcement shall notify a rape crisis center or support persons. But understand that people like victim witness and support persons, they do not have confidentiality and privilege, right? Keep in mind that the presence of a third person does not breaks or breaches confidentiality. I think someone mentioned earlier, yes. The presence of a third person, a third party, kind of destroys this idea of confidentiality. Now, federal VAWA and California statutes regarding victim cooperation with law enforcement. I'm just going to go ahead and read it directly from the book. The Federal Violence Against Women Act legislation eliminates requirements for victims to cooperate with law enforcement agencies as a condition of receiving a sexual assault forensic medical exam at the public expense, right? That was a clarification that was issued in 2012, right? So it is not contingent upon that. And so that is federal statute that says you cannot make one contingent upon the other, right? So you want to be really clear, make sure that your advocates, and as from what I hear from some of you, that is something that you want to make sure that your advocates are clear on, that it eliminates the requirement. And I think that was a requirement in the past, but since 2012, that has been eliminated, right? You do not have to cooperate with law enforcement in order to get your forensic examinations, right? So that's on page 92 of the training standards. If you need to get to it quick, it's right there. Okay, can we go to the next slide, please? Advocates will need to know various statutes that are all enumerated within they're included in your training standards, but they're also included in the advocacy manual, the advocates manual. And so you'll want to make sure that your advocates are clear on, they don't have to be legals, but what they do need to know is things like notification, rights, what they have access to, what they are required to do to participate or not participate, and so on and so forth. So you want to make sure that your advocates are clear on things like notification to the Rape Crisis Center on behalf of law enforcement, basic sexual assault laws, and the definition of sexual penetration, and how little penetration is necessary for the violation to occur. Right, so you'll want to make sure that your advocates are versed on those kinds of things, and in many instances, your advocates might be more knowledgeable, particularly around sexual assault, than law enforcement. Law enforcement, they have to kind of know, a much broader spectrum of criminal activity or crimes. Right, they have to know much broader. So then your advocates will need to know that. And again, I definitely recommend creating that little info card. That can go in your advocates ready go pack when they have to go, like, well, according to California Penal Code Section 261, blah, 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 right? They may have to do that as part of their advocacy and working on behalf of the survivors. So be clear with your advocates that there will be instances where they will have to clarify things or do some education with the local law enforcement officers. This is one of the things that your subject matter expert may not share with your trainees. Just keeping it real, okay? Next slide, please. So you want to make sure that your advocates know that depending on where they're going or where they've been called out to work on behalf of a survivor, that different locations, right, will engender different jurisdictional responses. Okay, so an assault that occur in one location, right? It's in Los Angeles. It was something as we would have things like, well, the assault occurred in Santa Monica, but then the survivor would wind up at a hospital in LA, or the assault occurred in LA, but then they would wind up in Culver City at a hospital. These are all different jurisdictions. And then your law enforcement office will say, we're not the ones you need to call. You need to call that law enforcement organization also. So just even in a place like, if you have an area where the boundaries between different cities or different small municipalities is not clear, and they can live in Culver City and then go to a hospital in Santa Monica, and that will come into play and can function as an impediment, unfortunately, toward appropriate or competent or careful law enforcement participation. Sometimes you'll have law enforcement agencies that will work together with each other, like they'll, LAPD might call Santa Monica PD, but by and large, they are very clear about the jurisdictional catchment areas and what that means, and those different jurisdictions will trigger different responses, right? So if it's if we're talking about assaults on a military base, the military base is going to want to conduct their own investigations, right? If it happened on a college campus, and if that college campus has its own sworn law enforcement organization, they may want to do their own internal investigation. Otherwise, they may call in the local municipal law enforcement to participate in the investigation. So jurisdictional issues will come into play, and it can all be very confusing to the survivor. Your advocate will manage expectations, right? We'll want to work very closely and explain that there are jurisdictional considerations. Everything's going to be okay. We're going to work through this together and manage those expectations with the survivors. Okay, next slide, please. So your advocates will want to make sure that they can communicate to the survivors the relationship between the different responders, right? So what is that relationship between law enforcement and the sane and safe nurses, right? What kind of conversation or communication is going back and forth between those entities, right? And when the nurse's office is calling the law enforcement because of an injury, or you may be on the scene before law enforcement arrives or what have you, again, people have different lanes, which means they have different responsibilities. And you as the advocate will center the survivor and make sure that the survivor, you can demystify things for the survivor. Well, the medical professional is contacting the legal professional for this reason, or the law enforcement officer cannot compel you to participate in an interview at this stage, right? So you want to make sure that that even as responders are coordinating response, what that relationship is and how that survivor should be centered in that process, and that your advocates are there, again, to stand up for the survivor and make sure that they are clear and are able to ask questions, right? That they are empowered to ask questions about their own treatment and their own participation in the law enforcement process in terms of interviews and investigation. They should know that they may not always have a successful investigation, that it may not go anywhere beyond registering the initial complaint, right? Again, managing, making sure that your advocates are able to articulate to the survivors what the processes are. Your advocates need to be able to say, this is going to happen, and then this is going to happen, and then this is what's going to happen. And that they are also including in that they may take your information, but nothing may come of it, right? Right? You just got to keep it real with them because of the way that cases may not make it through the criminal justice system, right? They might not, there might be credibility issues as far as law enforcement is concerned, or they may lack evidence as far as they're concerned. And so that may mean that their complaint gets deprioritized or that there is no further investigation. So your advocate will need to be able to articulate all of that for the advocate, again, in terms of managing their expectations, and so that they understand what's happening in the process, so they can be empowered to even ask questions on their own behalf. Okay, next slide, please. Okay, so the objectives of investigation, and your advocates will be able to inform survivors, again, what to expect, managing the expectations of the survivor. This is all very scary. This can all be very, very scary and very intimidating. And particularly, or can be even more so for some of those marginalized populations or disenfranchised populations, which we have, which you talked about earlier. You will have folks that might be recent immigrants, and they might be coming from countries where there might be civil war, or there might be high rates of law enforcement corruption, right? So there are all these different places in the world where folks might come here and they see somebody in a uniform, and that's what they understand based on their experience that they're dealing with, okay? So your advocates will need to assess that, work with your survivors, and encourage them to participate to the degree that they want to, right? And when the survivor says, that's it, no more, basta, I'm done, then that's it, right? But in the investigation process, if they want to participate in that, you want to make sure that you are conveying to them that this is what law enforcement is supposed to do. They're supposed to, quote, determine if an assault occurred. This is what the investigation will do. Determine if an assault occurred. Determine the location of where the assault took place. Determine who is responsible. This all takes place in the course of the investigation. Identify a suspect, right? Collect and preserve evidence. So that's why they go to the hospital, or they go to the clinic, or go deal with the sane or the safe folks. Make arrests where probable cause exists, and assist with the district attorney in the prosecution of the case, and provide testimony and evidence in court, right? So these are the responsibilities for those investigators. Right? So it seems very clinical, right? But again, information and knowledge can be very powerful and empowering to survivors. So you want to make sure that they have an idea of what to expect. If they should decide to engage in the process, and they're not having law enforcement folks do these things, right? That's a problem, right? So that they can say, I haven't heard back. They haven't followed up. I've called them on numerous occasions. I've told them where this has happened. They know where the perpetrator, all these kinds of things that your survivor might be worried about, right? So that they can then also participate in their own advocacy, should they choose to participate in the criminal justice process where law enforcement is supposed to do investigations, right? So it's really great when the survivor knows what the investigation process is supposed to be like, so that they can then sometimes have to tell the detectives, aren't you supposed to be doing this? Aren't you supposed to be looking into that? Have you followed up on my evidence? Has my rape kit been processed yet? Where is that, right? So that knowledge is power, right? Very good. So you want to make sure that they are clear on that, and your advocates are supporting the survivors in staying on top of those kinds of things for themselves, should they decide to go through the legal law enforcement, engage with law enforcement. Okay. Next slide. Okay, so I don't know how you can, this is on page 101 of your training standards, but here we have a little flow chart in terms of what happens with the forensic examination. So you're welcome to, utilize this with your advocates as they're going through training, but it certainly helps lay it out. If the victim wants an exam, yes, go here. If they do not want an exam, go there, right? So it lays this out in terms of a flow. And as you put together your advocates packet, the little go bag, you may want to put the flow chart in there also, right? So that they can refer back to it, along with the different penal codes or statutes or rights that survivors are entitled to. Include the flow chart also, right? So that they can, if this, then this. If this, then okay, then we go here, right? Right. You want to build the confidence of your advocates to be able to engage with all of these professionals, right? Because it will be very easy for the professionals to minimize or marginalize the advocate when the survivor is entitled by law to have the advocates be there, right? Now, having said all of this, we want to work with our advocates on the way in which they engage with these other professionals, the way in which they interact with law enforcement, right? The way in which they engage with medical professionals, or if they're on a college campus or a military base and what have you. They are also ambassadors to your organization and your program. They represent your organization and your organization's reputation and your organization's values, right? So you want to make sure that your advocates understand that they do not, that they don't get any power struggles with any of these people. Don't go toe to toe with any of these people. That's why you want to make sure that they have little cards with the penal codes or statutes on them, that they understand the flow chart, they understand the processes, so that they can speak intelligently and kind of assert the validity of and the legitimacy of them being in that space, right? So we want to have good, healthy working relationships with folks, but the advocate needs to first and foremost always remember that they are there to center the rights and needs of the survivor, right? Okay, any questions? I think that was the last slide. Is that the last slide? All right, I think we have, woo! I mean, just have to tell you all that Sarah and I were very nervous about how we were going to get through these three in one sitting with all of you. But I'm hoping that if you have any questions or if you have any insights or if you have any particular stories that you want to share that you think might be helpful for your colleagues and your peers, it would be great that if we could share or have some of that discussion now. Sarah, did you want to say something about the survey?
Yeah, I don't know what's happening to my slides. They're all over the place. Yeah, we also had that. Oh, there it is. I was like, what happened? There's kind of a lag on my internet today. So for some reason, it will skip ahead 2 slides when I only hit it once. So we have our last polling before we get to the survey. I think we have time for that. Yeah. Yeah. So just a couple of things as we like to do. Solidify a couple of points. I imagine that this should be easy for folks, but I will go ahead and launch some polling questions. You all know the drill. We'll do kind of a quick quiz here. And as you answer, just a reminder that it's anonymous, so we can't see who is answering in which way either. So if you don't know something, you won't be outing yourself. And then we'll share the results with everyone, and we can see how folks are doing, and yeah, drive some of these points home. So our poll question number 1 is: in California, does a survivor have to cooperate with law enforcement to get a forensic exam? Always, sometimes, or never. So in California, does a survivor have to cooperate with law enforcement to get a forensic exam? We have folks answering. We have about 65% of folks. Since we don't have a lot of time, I will be ending this poll pretty shortly. So if you haven't answered yet, if you're not sure, please go with your instinct, and I will close the poll in 5, 4, 3, 2, 1. So 6% say they always have to cooperate with law enforcement to get a forensic exam, 6% say sometimes, and 88% say never. A survivor never has to cooperate with law enforcement to get a forensic exam. Leah, would you like to let us know what the correct answer is?
Is the correct answer never? You never have to cooperate with law enforcement to get a forensic exam?
Yes, you should not have to.
It is not a requirement.
Not a requirement.
Again, that was an old understanding and old practice, but we've gotten clarification handed down that no, you are entitled to a forensic exam. They do need to understand that the purpose of the forensic exam is to check for injuries, but also to collect evidence. And it's okay that if they don't want to cooperate, that's fine. The evidence may not ever go anywhere, but they can get the exam and not have to cooperate with law enforcement to get the exam.
So poll number 2, confidentiality and privilege mean the same thing. True or false? We have folks answering pretty quickly on this one. Okay, if you have not answered, please feel free to do so now. Go with your instinct if you're not sure. I will close the poll in 5, 4, 3, 2, 1.
Okay, so the majority of you responded false. Confidentiality and privilege do not mean the same thing. Confidentiality is a broad set of practices that advocates will use where they do not disclose any kind of identifying information, and that what is shared with them, they hold in good counsel, right? Privilege is a right that is held by survivors that require certain professionals to not share. It is illegally, they are not allowed to share anything that was disclosed to them from the survivor. The survivor holds that privilege, and they can waive that at any time should they decide to do so, right? But the privilege speaks specifically to the prohibition of disclosing anything that the survivor said in confidence. Okay. Is there another question?
There's one more.
Okay.
So our last quiz question for the day is: it is okay for an advocate to function as a translator if there are no other options. The answers are yes, no, or it depends. We have a lot of folks answering. About 45% have voted. If you have not voted and would like to, please do so now. We're just about out of time, so I will close the poll in 5, 4, 3, 2, 1.
It is a best practice for advocates to not function as translators, okay? That's with family members, that's with nurses, doctors, cops, bosses, any of that, right? Because the minute you do that, you risk the potential of breaking privilege, right? And once that stuff gets disclosed, it gets out there, it's subpoenaable, it's all these other kinds of things, right? So as a matter of fact, I want to say in the state of California, those hospitals are supposed to provide translators, I believe. I can have that looked up, but I think that they're supposed to provide translators, certainly for persons with who are deaf and hard of hearing, they're supposed to provide translators. If you go through the criminal justice process, they're supposed to provide you with a translator, like if you're going to court. So no. Now, I get that when you're in the heat of the moment, your advocates might make a call, and that's understandable, but you want to make sure as a best practice, advocates say, I am not allowed to translate, you need to call a translator. Okay. All righty. With that,
That survey link in the chat. As always, please go ahead and take the survey on the way out. We really appreciate all your feedback.
that is terrific. Thank you all very much. And we'll see you on Friday, and bring your friends. And thank you also for your suggestions for future trainings. We'll take all of that into consideration. I think it's a good idea, and we'll see what we can do before the end of this fiscal year. If not, we'll see if we can't kick it off at the beginning of our next fiscal year, starting in October. So have a great one, everyone. Bye-bye.
Yeah.